Joined by former federal prosecutor Matt Coleman. You prosecuted your fair share of high-profile cases, including the former mayor Ray Nagin. We're all following jury selection of the voir dire of Charnel Fordish and Leon Parker in the staged Rex trial. When you're looking at jury selection, how critical is that to the case?
It's monumentally critical, for sure. It's a process that you're picking your audience, and those are your voters. They're going to vote for you or they're going to vote against you, and you need all 12. So no matter what side you're on, it's a hugely important part of the case. You can't necessarily control it, but you have to influence to the best that you can to meet your goal.
Let's just split this up here. As a former prosecutor, what kind of jurors are prosecutors looking for? Because look, just to explain this to people, this is the Eastern District Federal District of Louisiana. It's 13 parishes around Metro New Orleans, goes all the way to Washington and Tangi, touches Plaquemines and Lafourche. So it may not just be a jury of people from New Orleans, but if you're a prosecutor in this case, what kind of people are you looking to seat on this jury?
You're going to look for people that basically tend and vote more law and order along those particular lines. You might want someone who's not necessarily super young, because that particular demographic tends to be more liberal than conservative. So you're going to be looking for middle-aged to older individuals that really trust law enforcement, will vote for law enforcement, will trust in prosecutors, and are not going to be skeptical of what the defense is going to attack the government's case on.
All right. All right. Now let's switch over here. You do criminal defense work now. If you're a defense lawyer, and they have two good ones in this case, Sean Clark, former federal prosecutor, is one of the lawyers involved in this. If you're a defense lawyer, what's your dream jury if you're a defense lawyer in this case?
One individual is one that are going to be strong and they're going to be willing to fight back against, which will likely be, inevitably be, strong evidence from the government. They're going to have jurors that are going to vote for them inevitably. So you're going to need strong leaders that are willing to basically hold out, stick their feet in the mud, and be a little bit stubborn when they're skeptical of the government's case. It's very unlikely that a defendant in this particular case is going to be able to garner. And of course, I'm not prejudging the evidence, but it's a long road to hoe for the defendant, any defendant, to obtain 12 jurors for a legal verdict of acquittal. So I think one of the goals and strategies is likely to be from the defendant side is to go ahead and try to pick individuals that will obviously vote for the defendant's side, but also not cave under the pressure of deliberations, which is an inevitable likelihood.
So you've handled cases, I mentioned the Nagin case, that have had a lot of media attention. When there's cameras in front of the courtrooms, people on TV, newspapers, social media now are scrolling and can't stop reading about it. This is a case that coincidentally has had a lot of media attention. How does the judge in this case, Wendy Vitter, and the legal teams, how do they factor that in? Because this has gotten quite a bit of not just local, but national media attention.
That's likely to be the biggest topic that's going to be not only discussed, but individual jurors are going to be challenged on it. They're first going to be asked what particular exposure they have had, and then to what degree that has affected their pretrial opinion. And it's not just for a cause for challenge, I should say. It's not the legal standard that someone not have been exposed to any pretrial media. It's just the only time is that they become a juror that are not properly seated is when that individual juror says, not only have I been exposed to this, I have a concrete pretrial opinion that I cannot abandon. Regardless of what the court tells me in jury instructions, I cannot put that aside. That's the only time when a particular individual juror will be judged as partial, and they're biased towards one side or the other, and they cannot abandon that no matter what the judge tells them.
But one of the final questions here, it's so hard in today's world because a lot of these rules and these laws were written when the former media was a newspaper or a TV station that only did certain newscasts. We broadcast all the time. There's social media. We all have websites and we have social media now. After the jury's picked, how hard is it in today's world in 2026 when you tell jurors, many of whom, hopefully all of whom, are trying to do the right thing and focus on the case to try to limit your access to media exposure, because media exposure could mean a blogger in front of the courthouse that just jumps up on your Instagram feed and you don't want to see it, but unfortunately you see something that maybe you shouldn't.
Correct. In this day and age, it's not foolproof, but the court is obviously going to provide those chosen individual jurors with instructions that are going to be reiterated time and time again. I would expect that Judge Vitter is going to instruct those individual jurors to not look up, to not discuss, to not even get close to reviewing anything regarding this case. But to your point, it becomes harder and harder, especially when you've got individuals, let's say, that have not been exposed to, let's say, pretrial media exposure. So if we look at media coverage, to your point, 13 parishes making up the Eastern District of Louisiana surrounding Lake Pontchartrain, as far down as Grand Isle. Individuals in those parishes likely have not covered it, so to speak, or at least paid attention to the coverage as it would be in Orleans, Jefferson, and St. Tammany parishes. But once they're then in the jury room, it's going to be tempting for those jurors to not Google it, to not look it up, and start reading story after story, watching video after video. But jurors are expected to follow judges' instructions, and those instructions will be express, explicit, and reiterated a number of times. So we would hope that they would follow that. Of course, it's not foolproof, but that's the process.
Yeah, look, it's a great explainer because I think we're all fascinated by it. I go back to this. You use that. When these laws were put on the books, Google didn't exist. Instagram wasn't Instagram. X wasn't X. Now it is tempting to go to your phone and just get some background. But if you could talk about this, they're not supposed to do that. The judge is going to give them specific instructions. Look, as curious as you might be if you're picked for this jury, don't go to Instagram and search somebody's name, or Google and search somebody's name.
Absolutely. And as I said, it's not foolproof. The only way that you can actually, absent sequestration, which is not called for in this particular type of case, you have to trust in jurors that they're going to follow the judge's instructions. And if there's an issue where one of the jurors will discuss it with another person, that would be brought to the court's attention. But as we found over time, as hard as it is, for the most part, jurors have followed court's instructions in these types of cases.
Final question before we let you go here, Matt. I mean, look, just to circle back to what you started out with, this is it. I know a lot of lawyers in your position, and you've handled these before, feel like, hey, look, this is the biggest day, or even tomorrow, the biggest 2 days for me, because if I pick a really good jury, I'm going to feel really good about this case on whichever side you sit on, prosecution or defense.
Correct. And it's a roller coaster because you don't get to select who walks in the door. So as you've said earlier, there's maybe 100 jurors that have been summoned for jury selection. And many lawyers will call it not really jury selection, it's jury deselection. People are cutting. Both sides get a certain number of peremptory challenges. They get to exercise those. The cause challenges will be decided by the court. And then you're left with what's left over. And that's why every trial, no matter what the evidence, lack thereof, it's never tried in a vacuum. It's never tried in the four corners of a petition or a complaint. And it's literally up to those 12 individuals that, as we sit here, we don't even know who those people are going to be. They don't know who they're going to be. And so it's always to be determined, so to speak.
All right. Former federal prosecutor Matt Coman, we appreciate your time and your insight.
Absolutely. Thank you.